Hey, Jenny Bradley here with Triangle Smart Divorce in Cary, North Carolina, and I'm joined by my good friend Jason Walls. Jason, you want to introduce yourself?
Thanks, Jenny. Hey, I'm Jason Walls. I'm the Chief Legal Officer of the Walls Law Group, and we are located in Raleigh and Pittsboro, North Carolina.
Jason's going to help me answer a lot of questions that we get from clients. And so one of the ones we get a lot is, hey, I'm divorced now. My spouse doesn't get anything under my will anymore. I don't need to change anything, do I? And I just say, no, and phone a friend. But Jason, tell them a little bit about what actually happens when you get divorced to your estate plan.
Yeah, so certainly, Jenny, your estate plan needs to be updated. And you know, when we're talking about an estate plan, we're really talking about more than just your will. We're talking about things such as your powers of attorney, your healthcare powers of attorney, perhaps updating beneficiary designations. So when there's that life-changing event, such as separation or divorce, it's certainly time to update your estate planning.
And what I like to remind people too, Jason, is, we have this thing in North Carolina, it's kind of annoying in my practice. You've probably encountered it some too. You have to be separated for a year and a day before you can actually get divorced. Yeah, you might be able to work out everything else, equitable distribution, division of debt, support, custody, and all those things. But you got to wait around for a year before you can get divorced. So actually, it's not wait till divorce to update everything. You need to go see someone like you sooner, because if you have your spouse on your advanced medical directive and you're separated, they have the right to, well, let's just say it, pull the plug, right?
Yeah, no question. And you're exactly right. During that year of separation, there's a lot of changes going on. There's a lot of changes, obviously, to that marital relationship, a lot of changes probably to their finances, their estate. And so certainly updating that. And you make an excellent point. Just because you're legally separated, that does not automatically remove the spouse that you're beginning that divorce process with from being a key decision maker for you. Whether that's your healthcare documents, whether that's maybe your financial power of attorney, perhaps even the trustee of your trust or the executor of your will. Not to mention perhaps being beneficiaries on certain financial assets. So certainly when there is a separation, it makes a lot of sense to begin to think about how do we modify, how do we tweak the estate plan.
Yeah. And I'll do a qualifier here. You may be in a divorce situation or a separation situation where you've gotten a financial restraining order against you. Certainly don't go changing beneficiaries or anything that would run afoul of that order. But Jason's right. You can change some beneficiaries on some things unless a judge has said you can't. And we've had some folks not have things go the way they wanted. Well, let me rephrase. We've had some folks' estates not go the things they wanted because they didn't update their documents and their plan.
Yeah, and this is really where if someone is going through the separation process, it's a good opportunity for collaboration with their family and domestic attorney as well as an estate planning attorney, and making sure that that client has protections from both ends of kind of that legal spectrum, from a family and domestic perspective, as well as from an estate planning perspective.
Okay. And Jason, you talked about this a little bit in the beginning, but there are a lot of documents that go into an estate plan, and a lot of people just think of a will. But there's more to it than that. And so for the person that's watching this video that may not have an estate plan at all, jumped right in and thought, well, I don't need to change anything because I don't have anything. Can you explain a little bit about the documents you're talking about, kind of, make it 101-ish for folks, and then talk about, I guess the best way to say it is, and I kind of hate saying it, but marriage is going to end. It's going to end either in your office through a trust plan, through an estate plan, or through probate for somebody who doesn't have an estate plan, or it's going to end in our office through a divorce. So we're not the most popular people in the room when we talk about this kind of thing. I get it. But you're going to end up needing one of us at the end of your marriage, just depend upon what causes the end. So maybe back up the train a little bit and give us a little overview to estate planning.
Yeah, thank you for that question, and you're right. Although I want to say that I think I'm always the most popular person in the room, so at least I'm going to tell my wife that, right?
Well, you are until you start talking about a certain sports team.
Well, we'll keep that on the next video, right?
Okay.
So when we talk about estate planning, first of all, the thing I would suggest is that estate planning should be specific to the individual. And we're really talking about a strategy here. the documents are kind of the tools that we use to implement that strategy. But traditionally, when we talk about estate planning tools, we think of things such as a will or a trust, and those are two different tools. I explain to a lot of clients that a will is essentially a letter of instruction to the probate court. It basically says who's in charge of your estate when you die, is what we call your executor, who gets your stuff, that's kind of the beneficiaries, but it's a letter of instruction to the court, which means it's got to go through the court system. A trust is what I describe often as more like a contract between you and your beneficiaries. And I would submit that for a lot of people, a trust is probably a better estate planning tool than a will. And that's really where you need to come in and speak to an estate planning attorney to really understand which is the best tool for you and perhaps your beneficiaries. But then we get into things such as your financial power of attorney. Super important document that defines who would be in charge of things if you were incapacitated or disabled. My family had this situation with my grandmother. We knew that when she started putting her her car keys in the refrigerator, and she started making large donations of money to various organizations that had reached out to her over the phone, that we needed to make sure we kind of controlled those assets through her power of attorney. Then we think about things such as your healthcare decision making. And at the forefront of that is going to be your healthcare power of attorney. Who have you appointed to make potentially life or death decisions for you? If you can't do that for yourself, then along with that, we think of things such as the living will, which I often refer to as the pull the plug document. Defining kind of end of life care. And then for those folks who have young children, and we define young children as under the age of 18, making sure that we've identified who has been appointed to be their legal guardian. So all of those pieces are part of this toolkit that kind of helps create someone's estate planning strategy.
Thank you for that, Jason. I wish that you had taught that in law school, because maybe I would have got a better grade. That made a lot more sense than what I learned. I think that it's also important, you mentioned young children, it's also important for folks with young children to know that sometimes they'll come to us and they want to do things by contract, they want to do a separation agreement, they don't want to end up in court, which is smart. Love it. I think keep your stuff out of court as best as you can. And then they'll say, but we want to be we want our children to be the beneficiaries of life insurance policies. And we immediately don't know as much as you know, but start raising the red flag and say like, whoa, wait a minute. Like your child is under 18. They're not going to get this money. It's going to go straight into the court. And then somebody's going to have to petition and do this and petition to do that and et cetera. And all the ways I don't even know how it works, but I know enough to run from it. That's somewhere where a trust is also a big advantage, because you can make the trust the beneficiary of your life insurance and spell out in the trust how you want your child taken care of, what the money can be used for, who can control that money, when the child may get the money if there's any left over, when they become a certain age and all those kinds of things, which could be 22, could be 30. All depends on your child, as you said, a very unique, specific document, right?
Yeah, without question. And I think you're exactly right on the money with the conversation of life insurance, because for a lot of people, that's probably their largest asset.
Yeah.
Maybe retirement, but life insurance, especially if they have younger children. And I'll share with you just kind of a quick story. When I was much younger and my hair wasn't as gray, I had a situation where we were helping a lady who was the guardian for her minor niece. And unfortunately, this young girl lost both of her parents in a car accident when she was 12 years old. And like a lot of relatively younger families, the major asset that was transferring to this young girl was going to be life insurance. In fact, mom and dad both had $1 million life insurance policies. They were killed in a car accident. And like a lot of people, mom and dad had each other as the primary beneficiary. And then their contingent beneficiary, they had named this young girl. And unfortunately, in this scenario, mom and dad both died. The insurance company is not going to write a 12-year-old $2 million check. Nope. So the aunt had to go to court, open up what's called a guardianship estate. Now let's fast forward this just a little bit. So she inherits $2 million when she's 12. At age 18, she knows at that point that she is worth more than her aunt and her uncle. Right.
Right.
And at that point, unfortunately, this young lady started making a series of bad decisions. And guess what the first thing she bought when she got her money?
I'm going to think a crazy sports car, but I'm probably wrong.
740 BMW.
Okay.
Right.
I wasn't too far off.
It was nice. It was a very impressive vehicle. And unfortunately, that also led to a series of other bad decisions. She started dating someone who, let's just say, was age inappropriate
Okay.
for her. She decided that she was going to spend about $50,000 of her money paying off his back child support.
Oh,
Yep.
great.
And let's just be real, that was probably not what mom and dad wanted to have happen, right?
I don't think it probably was.
So what would have been a better strategy for mom and dad is to structure things so that their life insurance would go through a trust. And the same thing with clients who are going through the divorce and separation process. And again, this is where collaboration between family law attorneys, estate attorneys, really working collaboratively for the benefit of their client is super valuable.
Yeah, I bet you've seen us family lawyers make a lot of mistakes that you've tried to clean up as in the estate, right?
Well,
you can be honest.
So I will say sometimes family and domestic attorneys don't have the experience and really understand kind of some of the language that they're drafting in a separation agreement. What does that practically mean if there is an incapacitation or if there is a death?
Yeah, I've seen some of those come across my desk. I like to think that I don't make the mistakes now that I made 20 and 30 years ago, but I still have my language vetted by someone like yourself to say, like, does this make sense? Is this getting us to where we want to go? Let's talk about timing for someone going through a separation and divorce. When should they come see someone like you? Does it depend upon if they have a plan already in place? Does it depend upon if anything's going on in the separation or divorce yet? Or is it like me where I say, if you're thinking about it, you should go see somebody?
I think you're probably correct. Once the decision has been made that the marriage is going to reach some sort of dissolution, whether that's going to be through a separation process and then ultimately divorce, or however the parties are working that out, at that point, that is a life-changing event. And it makes a lot of sense for that person to come and update their estate planning. And again, this is kind of where collaboratively the two firms can work together to make sure that kind of both strategies, the estate planning strategy and the divorce and separation strategy, are working together and not kind of incongruent.
And let me ask this, because believe this or not, this won't be surprising to you, probably, but there are a lot of people that come see us who don't have a plan at all. No will, no, as you called it, pulled the plug document, no healthcare power of attorney, nothing like that at all. Is the default in North Carolina that until you are divorced, your spouse, whether you're separated, whether you're living together or whatever, is the person that the doctors will go to ask these questions of?
Yeah, it will be. And so we get into a range of issues, not only related to healthcare, but financial decision making. We also, if that person were to die in the separation process and there's not a separation agreement that's been codified, then we're looking under the intestate succession laws of North Carolina. And that spouse, depending upon the family structure, could walk away with everything or certainly a portion of their now separated spouse's estate.
And it's a little direct of me to say, but if you've decided you're going to leave your spouse, you certainly don't want that person making the decision about whether or not you live or die if you're in that situation in a medical hospital. So I go see Jason sooner than later is what I would say, not let's be sure that I know that I'm getting divorced. Let's do this when I know I don't want to be with this person right now.
Without question. And as it relates to the medical front, there's a lot of very practical things, such as most likely every time you've gone into the doctor's office, you filled out a HIPAA form for them, right? And you've identified your spouse most likely as a key person to contact. Well, during the divorce and separation process, the last person that you want most likely on that list is going to be that party or that spouse that you're perhaps battling out over finances or child support or custody or whatever that may be.
Sure. I mean, if you're in an amicable separation and you're like, we just can't get along anymore, we were good friends, we are not meant to be together forever, could be a different situation because you still trust each other. But certainly in your more high conflict and toxic situations, I can't imagine that you're separated, you've moved on, you're dating, you're going to, let's just say it, a certain doctor to get a certain prescription or something like that. You probably don't want your wife necessarily to know that you're doing that, but that's fair game, and be sure you change your phone numbers, not just your HIPAA.
Yeah, and so this is again where sitting down with not only the family and domestic attorney, but an estate attorney, and making sure that both of those professionals are working in your best interest is super valuable.
Yeah, well, thank you, Jason. That is a really not only smart, but responsible way to deal with the things nobody likes to deal with, but the decisions that can happen if you're incapacitated, if you were to be disabled, if you were to die, and certainly if you're heading towards divorce, to make sure that everything lines up so that your family gets what you expected them to get, not what some law in North Carolina may say.
Without question.
All right, and Jason, now I want to talk to you a little bit about life insurance, maybe dig a little bit more into that, because we see it a lot where folks want to do the right thing. They want to have some protection in place and say, hey, just because we're separated, just because we're getting divorced, we had life insurance together as a couple. We want to be sure there's something in place to help protect our children. But people are coming to us with provisions that used to be the old days rocket lawyer, now it's AI, or maybe it's a lawyer who borrowed a template from someone else, and we're saying like this isn't good language, this doesn't get it done. And I imagine with you having been on the other side for when someone does die and that's triggering event for life insurance, you've seen some of these documents I'm talking about, you've seen some of these clauses. And so what are some things people who may not yet be ready to pay a lawyer to review their agreement should be running away from with their hair on fire if they see in a separation agreement proposal?
Yeah, so specifically, Jenny, as it relates to life insurance, that's a really big piece of someone's estate.
Yeah.
You know, if we take perhaps the home value off the table, you know, for a lot of people, life insurance is that largest asset. It's the largest amount of money potentially going to your children. And so we have to be very careful as to the language that is in the separation agreement and understanding how that then passes. In many cases, we're talking about a situation of a minor child.
Sure.
Or maybe a child that's a young adult. So, you know, it's common that, you know, separation agreements are not, that language is not concise, it's not specific, it's not really connecting the dots between kind of family law and estate law. I was sharing with you earlier, we had a case that we had to take, unfortunately, all the way up to the North Carolina Supreme Court because a separation agreement of our client was really not well drafted. They unfortunately did not go to an experienced attorney, and the language was what I would call kind of sloppy. Mm-hmm. Our client passed away, and now we find ourselves in a situation where we're litigating over who is the proper beneficiary of life insurance. And this was a 7-figure asset. Mm-hmm. So that is, again, where the coordination between family and domestic attorneys and estate attorneys are so important. We actually developed something in our office that we call a divorce trust, which is a special type of trust that has some unique features to it for those types of clients that are going through the separation process. You know, for many people, they'll have an estate plan, but Jenny, unfortunately, the financial aspect, the type of assets that they have don't align with that financial or with that estate plan. Mm-hmm. So now we have these kind of the situation where we have pieces that are incongruent. And when you add a client that is going through divorce and separation, that's just an additional level and this additional layer. All those pieces have to be sewn in together.
Yeah, and I'll say, Jason, and this is probably contrary to financial planning advice, but we often discourage people from agreeing to have life insurance in place for a couple of reasons. One, because we operate against the background of what the court will do. And the court of North Carolina, as of this time, as we sit here in 2026, they cannot order anyone to carry life insurance for anyone else's benefit. So in a agreement, it's dangerous sometimes when you have a 2-year-old child to say, I agree, I'll keep $1 million life insurance policy in place for the benefit of my child. Problems with that. First one is, we assume you're going to be insurable, and that's a big assumption in this day and age. Second problem is, we assume it's not going to be cost prohibitive, and it could be, depending upon your age and your medical condition and other things. And the other one is you never want to leave it for the child's benefit who's 2 years old, right? And these are the things we're seeing coming across our desk. And, I'm scratching my head and trying not to sound like the jerk and say, like, we don't need to be agreeing to life insurance. You can be cooperative and go get this done by what you're talking about with a divorce trust. But I think people's fear is if it's not in the contract, it's not enforceable, and I can't be sure that this is in place. And a solution we've often floated is, well, if you're the one that wants life insurance on this person's life, you can be the owner of that life insurance. And now you don't have to worry about premiums not getting paid. You don't have to worry about beneficiaries getting changed. Because this may be shocking to some folks, but just because the separation agreement says the trust shall be the beneficiary, the trust doesn't know that. The company holding the life insurance policy doesn't know that. They're not a party to that agreement. And they're going to let happen whatever you do on a piece of paper for the beneficiary designation. And so if you don't have really, like you said, tight language, concise language around here, you can really end up with a headache. And it's not going to be your headache because you're going to be dead. It's going to be your family's headache trying to clean up the mess and paying lawyers to go up to litigate. And at the end of the day, my recollection of most cases have been whatever's on that piece of paper with the insurance company is what controls who the beneficiary is, and they could give two hoots about your separation agreement, court order, or anything else. Yeah, so it's a real careful area, and it's one of those where you save money by doing it yourself, but you really pay on the back end.
Yeah, there's a lot of danger in kind of do-it-yourself legal planning.
Yeah.
And people always think, oh yeah, you're a lawyer, of course you're going to say that. Well, we're saying that because we have years of experience of seeing that. We've seen a situation where, unfortunately people try to put together things themselves, whether that's through an AI bot, whether that is through some type of document that they found off the internet, or one of my favorites, they'll speak to an attorney who has no experience in this area. And the attorney is trying to be nice and give them advice. Look, I'm not the right attorney. If you get a speeding ticket, don't ask me what you're supposed to do, right? Or if you get into a car accident. And so when those things happen, when we have these documents that haven't been reviewed, they haven't been carefully thought through, then at some point there's going to be a problem.
Yeah, I call that the law of unintended consequences. And that's what we want people to avoid, whether that's using us, whether that's using someone. This is important. You need to be smart, you need to be strategic, but most of all, be responsible because you're protecting your children's future when it comes to life insurance.
Yeah, there's a lot to lose.
Yeah. Okay, Jason, so you've laid out some great stuff about being strategic. How can people find you? Because they better be watching this video and knowing they need to.
Well, thank you for asking that. So simply, you can find us online at wallslawnc.com. That's probably our best ways to reach out to us online. So, of course, nowadays you can find us on Facebook, Twitter, Instagram, all of those things as well. But generally just kind of reaching out to us through our website is usually the best.
Okay. And same for us. You can find us at trianglesmartdivorce.com if you are going through a separation or divorce or thinking about it and you want to know more about how to be strategic and plan smartly. You can also give us a call at our number, 919-977-7007.